Yes.
Thank you, Dr.
As soon as Mr. Brown is done. Okay, the boards are now back in session. Mr. Acker, you had an issue?
Yes, I'd like to ask the board to amend the agenda to include a authorization to retain legal counsel. This is the Poinciana West Board only, not the Poinciana Board, to retain legal counsel for a board member under the defense and indemnification resolution based on a document that I received concerning statements that were made at a neighborhood meeting. I have reviewed it. I do have no concerns over what happened. However, the document did make it to my attention, and I would suggest that that the board authorize the hiring of legal counsel, which would be separate from my firm, for this individual board member to deal with the questions that have been posed about the comments that were made at a non-board meeting where I understand no other board members were present. However, somebody has made a report and questioned that. So with that said, I'd be asking the Poinciana West Board to authorize the retention of legal counsel on behalf of Supervisor Vento, as well as directing district staff to notify the district's D&O insurance carrier. And again, this is an abundance of caution. We have a defense and indemnification resolution that defends all board members under circumstances like this, and so I would ask that the board go ahead and do that. We don't need to have a long, lengthy discussion about it unless that's the direction the board wants to go, but I'd be asking for that authorization so that we can deal with these allegations.
Is it a vote or is it a motion?
It'd be a motion by the Poinciana West Board to direct the district to retain legal counsel, subject to Supervisor Vento's approval, of course, and then go ahead and turn it over to the insurance company. But again, I've investigated the facts. I have no concerns over what the questions are. And so, again, I think this is an abundance of caution thing, but it's something that every supervisor is entitled to a defense by this board under the circumstances outlined in our resolution.
I'd like to make a statement if I can. I am the board member that this action was filed against. This alleged situation occurred at a neighborhood meeting last Monday, September 18th, where a question was asked as part of our for the benefit of the group section of the agenda. The neighbor asked if I would give an update on the CDD amenity sale. I said the following. Number one, I mentioned the court ruling on the bond validation. I explained that there were 5 items that needed to be met for the bond validation. We easily met 4. The 5th one was dealing with the methodology of different assessments was not accepted. Number 2, I mentioned that in our agreement, the mutual agreement that has been signed, AV Homes had agreed to pay the difference for those lower assessments. That was the problem with the bond validation. Number 3, I ended with letting them know that there was a meeting scheduled for today. At the meeting, the boards would be addressing their next step. There was no other CDD board member at the meeting, and the information I provided was all public record. I find it highly unprofessional that this action was filed on alleged statements without the person witnessing them or being in the meeting. It was simply hearsay. And to file an action of this type merely based on hearsay is unprofessional and unacceptable. Thank you.
Thank you. And I move to authorize legal counsel in defense of my fellow secretary.
I second the motion.
All in favor?
Aye.
Aye.
Can I
Yeah,
vote?
I would abstain.
Then there's an
Direct you
opportunity.
to abstain, and we have
All right.
a majority of the members present here today voting.
I will abstain. Thank you.
Okay, that was the one item that we needed to talk about here today. Certainly, we're now to the supervisor comments portion of the agenda.
Okay, so supervisor comments, do we have anybody, any supervisor points in CDD as an issue? Comment? No? Okay.
I think I've done all my comments.
Any other comments? No here?
No? Okay. No other comments from supervisors. I'll open the floor up to audience comments. Please come to the microphone. State your name and address, please.
Barry Taylor, 213 Division S. I guess I have a question. District Council has said on a couple occasions today that bond validation essentially is a moot point at this time because of the class action lawsuit. And the class action lawsuit, I think you said could take anywhere from 3 months to 7 years in that kind of time frame. I guess I just have a question then, why the board is continuing with the bond validation with the class action looming over it. I mean, essentially, you're having the district council spend a lot of time on something that might not come to fruition for a long time. Thank you.
I'd just like to say, I think if we wait till it's over, just say it does end in 3 months, then we'll have to start at that point. So my thought is to go forward as far as we can go, and then when we get to the point where we don't have to do anything more, stop and hold off until the class action suit is over.
How long does the bond validation last after we get?
Well, we're going to be back in active litigation, or still in active litigation, but I would anticipate if we can start our assessment process in October, at our October meeting, that would be about a 45-day process, so then you're, at Thanksgiving, and you can file your validation. We can have that ready to start in October, if the board wanted to. And so then you'd be looking at a hearing date in January or February would be my best
So my
guess.
question is that if we were to get bond validation, is that good for 1 year, 5 years, 10 years, 20 years? What is the length of validation?
Keep going. It's forever.
So it's forever. So it's something that we would always be able to use, even if we chose not to do this deal at this point, but wanted to do something else at a later date.
That's yes and no. If you're doing a totally different project that you've never validated, then that's a different issue. You have to go back through validation.
Just to follow up to what Mr. Brown is saying, just my personal opinion, I think it would be fiscally maybe a little bit more prudent to just say, with the class action looming and hanging over for an unknown length of time, maybe we should just table everything as it is, not spend any more of district council's time and money, and wait until that's resolved. Because like I say, I haven't heard of anything from AV Homes or the plaintiffs said, it could easily be 5, 6, 7 years. Thank you.
Thank you for your comment.
I just want to again remind the board that you're being asked questions and things by people who you're in active litigation with, so please keep that in mind.
I'm not.
Right. Are there any other comments?
Earlier in the meeting, Mr. Eckert characterized my role in this litigation. I should make it clear, I speak at the podium only for myself. In the litigation, my role is as a client. I'm a corporate director of the Save Solivita Amenities Fund, Florida nonprofit corporation that originally retained the Bush Ross law firm.
And members of the board, Mr. Gundel is a licensed attorney. He is not opposing us in the bond validation case as a party. He did sit at the council table and assist the lawyers throughout that case. So in my opinion, he is acting as a lawyer on behalf of the people who are contesting your bond validation, and I stand by that.
Good afternoon. My name is Jesse Brooks. I live at 189 Couple of Loop. And I'm a little confused. So maybe you can help me out. I heard a little bit earlier some of the board members say that, first somebody said it was just, this is really about the money. I don't remember who said that, but hopefully you will. You remember that? Somebody said that? This is basically underneath it about the money. The other thing I heard was that, well, this is still an active negotiation of sorts. It's not finalized. And so, is that true? We're in an active negotiation still? Is there a counter offer to the offer that was on the table made by the CDD as a part of the negotiation process?
Again, I mean, we're in active litigation. We're about to probably refile for validation. Again, I mean, I don't recommend the board start engaging in protracted discussions about this issue.
This is something that's already happened, not something that's it. I just wanted to know what was there. A counter offer to whatever the offer that was made earlier is my question. I didn't know whether there was or not. Okay. So if it is about the money, then maybe you can think about these three questions. I know that maybe underneath it is, because you can take a poll in here in terms of how many people really want to have amenities. I'll raise my hand. I want it. Anybody else want to have amenities and all the things that we have? If you raise your hand. I think everybody does. I'm just saying. So part of the survey is here. But the question is, under what conditions? So there are three questions. Do you want to have amenities at any price? Do you want to have amenities at a fair price? Yes. Or maybe the third question would be just nothing at all. How many people would want to say that it's at any price, doesn't matter any price? Fair price? Not at all? So my point being that if it is about the money, I'm sorry, sir. Thank you, David. I think you said a little bit earlier, well, yeah, we could talk about maybe having it be at 60 million or something to that effect in terms of negotiation with that. And perhaps that's what the issue is. It's not that people don't want to have the amenities. It's that they want to do it and want to know that at least it's been talked about and done at a fair price. There's a way to figure out that you have discussions to do that. And I would hope that at any given point in time of our lives, if we made a decision that we've done something, that we have new information or different information. And I want to talk to Mr. Keller.
Sir,
I understand.
3 minutes is up.
I understand. Will anybody give me one more minute?
Well, that's not their decision, but go ahead.
Thank you.
I'll give it
Mr.
up.
Kellogg said a little bit earlier about what this has done to the community. And maybe they're taking a step back from doing that. And I want us to think about what it has done. And maybe if we look at what can be figured out as a fair price, if there is an ongoing negotiation, please let's look at doing that. Because I think that's really what the issue is here, more so than anything else. Thank you for your indulgence.
May I make a comment?
Who are you? What's your address?
Oh, I'm sorry. The name is Martin Kessler, 759 Lago Pass. Do I understand that the contract you have today is terminable based upon your decision because we are still in the inspection period? Is that right or wrong? Do I hear an answer?
The terms of the contract, one of the things that's a condition preceding to us closing is the successful validation of the district's bonds.
Well, is the contract effective or is it still in the inspection period? Is it done?
The contract is in place. We are in the inspection period that has been extended from time to time.
So we
And
do not have an effective contract.
that is not correct, Mr. Kessler.
Well, we do have an effective contract, but it's still being extended.
Dr. Kessler, are you still intending to litigate against the district? If so, then I'm going to terminate in terms of answering your questions. So what I'm saying is that we have an inspection period. We're currently in the inspection period. One of the things that this board has to do in order to close on the contract is to successfully validate bonds. So if we wanted to close on the contract, we have to go back through bond validation.
You cannot close unless you have bond validation.
Under the terms of the contract, that is correct.
Is the contract effective in terms of real estate law? Or is
Yes.
it not effective?
The contract is currently in effect.
Is it currently what?
In effect.
You say it's effective?
The contract is currently in effect. It has not
So
been
you do not have a
terminated.
valid contract with AB Homes?
Dr. Kessler, I'm probably going to stop this now, okay?
Well,
We have a contract, members of the board, we have a contract with AB Homes to purchase the amenities. There are some changes that you've asked me to look at making to that contract. That contract is currently in effect as of today.
Okay. Does AB Homes have any right to terminate the contract if the bonds are not validated?
Members of the board, I'm not going to go through a deposition here today.
Okay.
I spent 5 hours doing one, I'm not about to do it again.
Do we know whether or not AB Homes, since the bonds are not validated, is AB Homes free to sell the recreational assets to a third party? I have a buyer who would like to buy
Members of
it.
the board,
Yes.
I'm not going to engage in this discussion. It's public comment. If Dr. Kessler would like to make comment.
Dr. Kessler, yes.
I can't get any.
Do you have any other comments to make besides questions?
I can't hear that.
Do you have any other comments
No,
besides
I
questions?
heard enough, thank you.
Okay.
I'm Patrick Musto, 832 Pacific Ridge Road.
I'm sorry, I didn't catch your last name.
Musto, M-U-S-T-O. First of all, I've sat on similar boards and faced similar audiences. You have my sympathy and my appreciation. I'm a new resident, just moved in May, and did not know anything about the lawsuit until I got that little thing in Reflections magazine and thought I was being sued.
Essentially, you are a member of the...
I realize I am. The problem I have is getting information. I mean, you get information at the pool, you get information at the golf course, you get it at the grill, you get it online, which I don't trust. I mean, you have the advantage of, you've been working on this for a year and a half, and you've, been there, done that. Well, where do we get the information to find out that, is it $20 million, is it 70-some million dollars, and why the difference, and how could we make a decision when, I mean, judging by the number of new homes in our development, there's got to be a lot of people in my situation who are just walking into this, who don't have the faintest idea what's going on, and can't make an intelligent decision. Where do we get the information?
Normally, you would get the information from board members, but because we are in litigation, we have been advised by counsel not to speak about it.
Yeah,
Well,
that does put most
no,
residents in a different...
I want to answer your question, and there are minutes of these meetings, and there are videotapes of these meetings. All of our records in terms of the purchase and sale agreement that we've kind of been talking about, that's a public record. Anybody can look at that document. Anybody can look at the bond validation judgment. And so if you want information, they really mostly are all public records that we can provide.
I started going through the judge's decision and fell asleep. Okay. Somewhere, can't someone produce a 3 or 4 or 5 or 10-page summary of this is where we are, so that anybody who wants to take the time to do maybe a half hour or an hour of reading can find out how we got here, and then then you can just periodically add the next page as things happen or don't happen so that we can get the information we need?
Yeah, there's a Q&A that's on, I believe it's on the website that we prepared. It's out of date since we had the validation judgment, and so I think it would be appropriate for the board to update that after they make some decisions at their next meeting in terms of providing that information. But we did try to do that, and we just need to update it once you guys finally make some decisions at your next meeting. But that's a good thought, though.
Mike, also, all those things are on the
Thank you, Mr. Marcelli. Thank you.
All the documents are on the Poinciana CDD website.
Many of them are.
Patricia Schmidt, 772 San Rafael Street. The board, with all due respect, spent in excess of a half an hour discussing a survey. I just have so many questions, I'll go beyond my time limit on it. However, the most important one is there are national statistics that prove that no matter what your survey is or whatever your marketing is, if you get back a 10% response, that is good. So my question is, who's going to decide if only 10% comes back? Is that enough of a response? Okay, and then you're going to turn around and say, oh, we didn't get a good enough cross-section. Let's send out another survey. Let's have this question on the survey. Who's going to decide what questions go on the survey? I mean, you are opening another Pandora's box. And we have been going around and around with this issue for more than a year and a half, because I happen to know I was at meetings back in November of 2015. November of 2017 is 2 months away. So guess what? We're a year and 10 months. I'm not stating whether or not I agree with the price that is being negotiated, but it is a legally binding, fully negotiated, executed contract. And all I can say is, you people better straighten out your ideas on things. You have to get on the same base. We as a community have to unite. This is a spectacular community in which we live. Solivita is second to none. And let's treat it that way. There are so many things here that go on. This is a disgrace that there's such division among the residents here. Who the hell is going to live 30 years anyway? Okay?
Thank you, Ms. Schmidt. Are there any other comments?
I'd just like to make a very quick comment.
Name and address.
I'm Donovan Brown at 687 Glendora Road, Solivita. We formed a group called Solivita United. We sent out petitions asking people if they wanted to support the efforts of this group. And we got it in, after all the snowbirds had gone, we got a very good initial response. But we have over 2,000 signed petitions saying that they support the action that you're doing. And I think that far exceeds the group that's opposed to what you're doing. And we would like to see you carry forward and get this job done. Thank you.
Thank you, Mr. Brown.
David Roy, 125 Rancho Mirage Drive. I guess I'll take a little bit to the other side, hopefully Pat can give me the elbow since I'm super side. But I kind of like the idea of the survey for a couple of reasons, and I'll tell you why. First of all, I've been on boards like you guys, know how thankless the job is and how tough it is. I particularly happen to be one that supports the renegotiate the price, but that's immaterial. You guys don't need to be abused by it. I have nothing personal with any of you, including Tony, anybody else. You guys work to do your things right. But in my mind, if we're ever going to heal up, we ought to know where people stand. And I think it would make sense if the vast majority like the price and ought to move on, then I'll change my mind, move on, and here we go. If it goes the other way, I think you guys ought to consider that. If not, we're never going to heal up. I think that would help heal the community up to know where the vast majority of people think. If it's roughly 50-50 or whatever, you have to use your own judgment. Here we go. But somewhere along the line, I think that would help get closure for all different sides and would make things move a little easier on you guys and everybody else. And I certainly don't feel good about any animosities in the community. Hopefully they'll all go away when this thing's said and done. Thank you.
Thank you, Mr. Gordon. Any other comments? Okay. There being none, move on to the next item on the agenda, which is adjournment for the point ten CDD. May I have a motion to adjourn?
So moved.
All in favor? Aye. All opposed? Motion carried.
Point 10 West, motion to adjourn.
Bill Brown, move to adjourn.
Second.
Second.
All in favor?
Aye.
We are adjourned.